Hello, everyone, and welcome to the Reed Smith Salt Room. My name is Lee Zoeller, and I'm joined with Sebastian Watt. And today's topic is going to talk about the status of Pennsylvania's corporate income tax Addback statute and the appeals that are going on as a result of the new Addback statute. New was in 2015, but new as far as we go. A couple housekeeping items that we wanted to cover. One, if you have questions, there's a question window in the program here, and so please just type in your question and we'll respond by email to your questions. There's materials that are available. These slides are available, and they're in the event resources section of this program. So just click on that, and you can follow along and see the slides. The program is, of course, qualified for CLE and CPE credits, and one of the requirements for that is to answer the questions that we have embedded here in the program. So we would ask you to follow along and answer those questions so that the program qualifies for CPE and CLE credits. Okay, so the agenda for today. This is the agenda for today. What we wanted to do is really start with some background to get everybody up to speed on what the Addback statute says, what the exceptions are, talk a little bit about some of the Sham Transaction doctrine, because it still comes into play with respect to the Addback statute as well. And we're going to cover, there's 4 exceptions in the statute, as many of you are probably aware. We're going to cover those all, but we're going to dig into really the principal purpose exception, which is the one that, based on our experience, has received the most attention and gets the most activity in the appeal world. So we thought we'd spend a little bit more time on that than the other ones. Next, we're going to move to the assessments and the appeals. This is, I think, an important part of the program because this is going to give you some inside baseball about what's going on here in Pennsylvania, where the cases are, how many cases are out there, and kind of a little bit about the history of, intangible holding companies, a little history about Delaware holding companies and how we got to where we are. Then we're going to move to talking about some of the recent decisions that have been issued by the boards, Board of Finance and Revenue, Board of Appeals, and some of the cases that have been resolved on this topic in either the Board of Finance and Revenue or in Commonwealth Court. Then we're going to move to talking a little bit about, at least our view on defending these audits, what ought to be done. We always get the question, well, when should we get involved? When should Reed Smith get involved? And how do we handle the audit and those kind of things? So we're going to touch a little bit about that on that topic. And lastly, we're going to finish with kind of the newest, this is really round 3 of the Addback statute and Delaware holding companies, which is, does the Delaware holding company have nexus with Pennsylvania? So not denying the deduction for the company that's in Pennsylvania, but saying, oh, okay, we can't use the Addback statute, but maybe there's an option that we could use the traditional old nexus. Your Delaware holding company might be in Delaware or some other state, but maybe it does, in fact, have nexus with Pennsylvania, and we're going to issue an assessment on that entity. That's round 3. We'll get into the details on that. Interesting new topic. We'll fill you in on sort of everything we know about it, which is not a lot yet, but we've got some theories on it. And haven't seen any assessments on it yet, but interesting topic. All right, so that's the agenda for today. Again, thanks for joining us, and I hope you enjoyed the program. With that, I'll turn it over to Sebastian to kick us off here.
Thanks, Lee. Lee's giving me the dry stuff, the statutory stuff, and he's going to go through the fun stuff, the history. So let's start with the dry stuff, the statute. So Addback was enacted in 2013. If you're a calendar year taxpayer, it's effective starting in your 2015 year. This has been around for a little while, but you probably don't focus on this unless it's an issue for you. And we're seeing a number of more recent assessments. The department's activity has definitely increased in the last year or so. So you might not have focused on it too much yet. So what is it? What is the Addback statute? Well, it applies to certain expenses paid to affiliates. The 2 expenses that it covers are intangible expenses and certain interest expenses. So Pennsylvania does not have a general, broadly applicable Addback for interest expenses, but if they are related to an intangible, Pennsylvania's intangible Addback statute will apply to disallow interest expense.
There's a lot embedded in that, Sebastian. So I think what we're going to do, just so the audience is aware, there's a lot that's kind of embedded in all those things. We're going to sort of start to drill in and break it down piece by piece so that it's a little bit easier to digest. And it's fascinating, I think, that to me at least, that when you have a statute, and this is it that you're looking at on the screen now, that's really not that big. But when you really start to dig into it, each and every word, you can start to make arguments about, well, what does that word mean? What does this word mean? And we're going to walk you through that, which kind of give you some flavor to what's going on here in Pennsylvania.
Yeah, so let's take this piece by piece. So, the Addback is a presumption. It starts with a presumption that no deduction shall be allowed for an intangible expense or an interest expense with an affiliated entity. So what I just said before, but let's just take that. Let's take each underlying term piece by piece. So an affiliated entity, we don't really see a whole lot of issues here. Oftentimes, the vast majority of the time, the interest or intangible expense that's being disallowed is being paid to a wholly owned affiliate. So we don't really see too many issues here. You can imagine a situation where you enter into a joint venture with a third party, so you might own less than 50% of the entity that you're paying expenses to, but we don't see that too often. So what is an intangible expense? Well, the statute has got a long list of things that are intangible expenses or costs, the things that you would normally think about as intangibles: royalties, licenses. The most common thing that we see are expenses paid for the use of trademarks and trade names. So you'll have a company that has activity in Pennsylvania. It will transfer its trademarks and trade names to an out-of-state company like the Delaware holding company, and then pay a royalty for the use of those trademarks and trade names. That's the most common situation. But intangible expenses also include fees paid for the acquisition of intangibles. So if you were to buy an intangible from an affiliate, the amortization deductions or the fees that you pay to acquire an intangible are also subject to Addback. The statute has got a broad catch-all for other similar expenses. The department, that sounds pretty broad, and if you had any doubt as to how broadly the department was going to interpret that, they have issued a notice, Notice 2016-1, that really interprets that other similar expenses, interprets all these terms sort of as broadly as possible. The biggest sort of item that's not directly in the statute is embedded intangibles. So you think you have a management fee that you pay to an affiliate. It's not called a royalty. The agreement doesn't say anything about intangibles. But if you were to dig into the actual services or items that the affiliate, out of Pennsylvania affiliate owns that are being used by the Pennsylvania affiliate, there might be an embedded intangible there, or there might be a position for the department to take that there's an embedded intangible.
Yeah, I think I'll just mention here this corporate notices that came out, the 2016-1 that's on your screen there, goes through a lot of these embedded royalties, management fees, and I haven't seen so far any assessments along those lines. And we keep track of every case that's filed, not just the cases we have, but we have not seen it yet. So I get a sense that maybe the department's pronouncement hasn't got its way to the lawyers or the auditors, I'm sorry, that are handling these audits, because we've got a number of clients that have management fees and probably have embedded royalties as well. And even on the audit, it has not been assessed yet. So just I put that out there. If you're one of the lucky ones that has it, yeah, you're lucky. You're rare so far. And maybe it's during the audit right now. They're asking questions about it. But you take a look at the notice. You can see at least what the department's view is about all of that. And just one more thing on that, Sebastian. While I'm talking about the department's view, this corporate notice, 2016-1, everybody needs to bear in mind that in Pennsylvania, this notice can't be relied on by the taxpayer, has no force and effect of law. Pennsylvania you've got statutes that are statutory, obviously, force and effect of law. You have regulations that have gone through the regulatory approval process. Those have force and effect of law. But the corporate notices are like, instructions on the tax return. can't be relied on the taxpayer and shouldn't be relied by the Commonwealth either in the department in audit. So just bear that in mind. That's the department's view. It's like a letter ruling, right? That's all it is. It's the department's view about any given transaction. And if you have any doubt about that, we actually had a case that went all the way to the Supreme Court for Procter & Gamble on a sales tax issue, in which the department had issued a letter ruling exactly contrary to our position. And the department argued at the Commonwealth Court that, well, that should win the day. We should win this case because this letter ruling is out there and says the taxpayer loses. And our argument was, well, if that's the case, then there would never be litigation because the department could just write corporate notices all the time. We know what their view is. Now the court has to decide what the statute says and what the regulation says and interpret it and apply it to the facts. Just because the department puts out a notice doesn't mean that is the law. So I just want to make sure that all the participants are aware of that.
Yeah, if you have any doubt about what Lee said, and there's this case out there, the department promulgated a regulation that says just that. It says that notices are information for taxpayers and cannot be relied on in appeals. So it couldn't be more clear. I guess I'll also just say, going back to your point about the embedded intangibles in audits, we haven't seen, to your point, we haven't seen any assessments yet, but it does look like auditors are sometimes requesting intercompany agreements just to dig into the issue. So again, it looks like auditors are digging, but they haven't, as far as we're aware, haven't found anything yet. So that's intangible expenses. So interest expense. So I said earlier that Pennsylvania does not have a generally applicable add back for interest expense, and that's because interest expense is only added back to the extent that it is directly related to an intangible expense. That directly related language is directly from the statute. But if you're looking to try and figure out what that term means, it's not further defined in a statute or regulation. The department's position, again, going back to the notice 2016-1, has taken a pretty broad view of what is directly related. Their view is that interest is presumed to be directly related where the taxpayer and the affiliate engage in any intangible transaction. So just go through a couple of examples. And a couple of these are from the notice itself. So take a situation where you have a taxpayer that has an affiliate that has an intangible, say a trademark, and the taxpayer purchases that intangible from the affiliate in exchange for a note. And then so after the taxpayer buys the intangible, it is paying interest to the affiliate from whom it bought the intangible. That's an example of the notice that feels pretty directly related. The only reason that loan exists is because of this intangible transaction. The department's probably right that that's directly related. They go further than that, though. Same facts, but let's say 6 months later, the taxpayer borrows money from that same affiliate to buy real estate, for example. Well, in that case, the department is going to presume that that interest is directly related to the intangible transaction that occurred 6 months earlier. They're not going to dig into that any deeper. They're just going to presume it. It's up to you as the taxpayer to prove that interest is not related to the intangible. The third situation is not in the notice, but it's practically how the department applies or views directly related. Say you have a taxpayer that has two subsidiaries. One is an intangible holding company, and the other one is a financing company. The taxpayer has intangible transactions with the intangible company, say pays royalties, but does not have any intangible transactions with the financing company. All it does, and all it has ever done with that financing company is pay interest. Even in that case where there is no intangible transaction between the taxpayer and the financing company, the department will presume that interest is related to the intangible. That's not the view articulated in the notice, but practically that's how it works. And the auditors won't even go through the audit narrative and Board of Appeals decisions won't even go through the analysis of determining why that interest expense is related to an intangible, why an intangible transaction with one affiliate makes interest paid to another affiliate related, but they'll just presume it, and then their entire analysis will be around an Addback exception. They won't generally even address or conclude that the Addback statute is applicable in the first instance. It will just be assumed.
Yeah, and in fact, we have cases in which the department has assessed interest-only intangible holding companies, and in situations where there's no trademark company, just a interest-only Delaware holding company that holds a note to the taxpayer in Pennsylvania. They've assessed just that transaction alone, so there's no relation to any intangible at all in that case. So just so you know, and this is under the old pre-2015 and post-2015. So.
Just since you brought it up, obviously we're talking about Addback statute effective for years 2015. The department's been adding back these expenses for a long time under a different theory that we'll get to in a couple minutes. Okay, so we've covered when the Addback statute applies, and that's this language again applies to expenses, intangibles, and interest expense paid to an affiliated entity. Let's talk about when the Addback statute does not apply, or when there's an exception to the Addback.
This is where the exceptions, in our view, cut to the chase here a little bit, since people don't, the exception really eats up the Addback in our view. It just totally makes the Addback go away, pretty much. So with the exceptions that exist, so there's a huge presumption, and it's been clear based on what the auditors have been doing. Any interest paid to an affiliate, any royalty paid to an affiliate gets added back. Then the arguments start to talk around, well, okay, do we fit within one of these exceptions? And how does that work? And do we have arguments to take an exception to the presumed addback? Sebastian, you cover those four.
Yeah. So we've got four here. The principal purpose, we'll spend most time on that. I'll briefly touch on conduit and treaty. Addback is on this list. Pennsylvania statute does provide for a tax credit. If the recipient of the royalty interest payment is paying Pennsylvania tax, then you are entitled to a credit. Not a true exception, but it's sort of works practically like an exception. Not much to say on the treaty exception. I haven't seen this exception become the controversy of an appeal. Addback, the exception says that Addback does not apply when the interest or royalty is paid to an affiliate that is domiciled in a foreign country, and that foreign country has an income tax treaty with the U.S.
Yeah, I think two important things to mention here on this treaty exception. Number one is you don't have to have a business purpose. Number two is that the entity doesn't even have to be paying tax in that foreign country that has a treaty with the U.S. So two big things there. Again, this seems to be a pretty wide exception that most taxpayers should fit into if they're making payments to an affiliate that's in a foreign country that has an income tax treaty. So if that's an issue, it seems pretty clear. That's why we're not going to spend a lot of time on it, but I'm sure the department will have a different view of that. So there you go.
Yeah, of course, there are not income tax treaties with all foreign countries.
Yes.
For example, the U.S. does not have an income tax treaty with Bermuda, for example. So if you set up a holding company in Bermuda to hold intangibles and you're paying that, you're not going to qualify for this exception. You'll have to rely on one of the others. The second the second exception to Addback is the conduit exception. Basically, that says that if you're paying a payment that would be subject to Addback to an affiliate, and that affiliate is passing through that payment to a third party, that the expense is not put back. And that's just simply because if the taxpayer were making the payment directly to a third party, Addback would not apply. Again, Addback only applies to payments to affiliate entities. So because this payment wouldn't be subject to Addback, this one would not. The payment that goes through a holding company. The application.
This is the more fun.
Right. This is the more fun part. And so we talk about this just to kick it off.
Yeah.
If a taxpayer, it gets more complicated if the taxpayer is paying, or if you are paying a $10 royalty to an affiliate that would be subject to Addback, and then the affiliate is passing on less than the $10. In this example, we have $1 to a third party. The question is, does the taxpayer get to deduct the entire $10 under the conduit exception, or only the $1 that's passed through.
Yeah, and this is where, this is the first time we're going to mention some legislative history that I think is important. One of the benefits that we have of keeping a really close eye on how this statute was enacted, we've got all the legislative history, and you really see how the back and forth and the compromises get made in the legislature to come up with the final product. And this is one of them where you had two representatives in Pennsylvania have kind of dueling views about this. And one happened to be based on the MTC rule, which would say, in this example that Sebastian has up there, you get a credit for $1, okay? That would be the MTC rule. It's a proportion of the expense, proportional. So you get a credit for the $1. But that was the original proposed language in Pennsylvania. But when you go back and look at the legislative history, you see that. You see a couple of representatives in Pennsylvania going back and forth talking about this particular conduit exception. And what actually ended up getting passed is the provision that says a payment to a third party that's less than the payment made to your intangible holding company, you get the credit. And so the issue, and the representative proposed the MTC version said, well, that means if you pay $1 to a third party, you get a full credit for the $10 that's paid from the taxpayer to the holding company in Sebastian's example here. So we think there's some pretty good authority. The language supports it, but in addition to the language that's actually in the statute supporting the position to take a full conduit exception here on this example, we think that the legislative history really spells it out, because the initial version, again, was the MTC version, which would only give you $1 credit. Now the Pennsylvania version, we think, gives you the full $10 credit. So if this applies to you, it's something worth taking a good hard look at.
So the legislature had legislation in front of them that would have allowed the deduction for just the $1. They didn't enact it.
Right. Yeah. And so, the department, and just like, the lawyers just like us, can interpret it any way we want. But it seems to us that, when you get to a point where you're arguing before a court and it's not entirely perfectly clear, which, you can always make anything not perfectly clear. When you go back and you present this legislative history, at least the court has in front of it the legislative history that says what they really wanted, and what they end up doing is to giving a full credit in this scenario that Sebastian has up here. And I think there's some authority, there's some authority in Pennsylvania, some recent authority that we learned in handling our NOL cases that would suggest that the courts do consider what would the legislature have done and what did the legislature intend to do in the situation like this. So we think that authority would help us in making the argument that you get a full $10 credit here under the conduit exception.
All right, so the third exception, the most important one, and frankly, all of our appeals involve this issue. All the appeals pending in court involve this exception, and so this exception is incredibly broad. It says that Addback does not apply if the transaction did not have as its principal purpose the avoidance of Pennsylvania tax, and the transaction was at arm's length. So we're not going to spend much time on the arm's length prong. Generally that's met if you have a transfer pricing study. The royalty rate or the interest rate is not incredibly unreasonable. It doesn't say something like the royalty shall be equal to the amount necessary to reduce your Pennsylvania tax to 0, or it's not over 10%. If it's not too greedy, that doesn't seem to. If it's not too greedy and it's supported by a transfer pricing study, that does not seem to be the issue. The big question is what it means to have the principal purpose as being tax avoidance. And so before we even get to that, we have to ask, well, what is the transaction? What transaction do we need to look at to evaluate what its purpose was? And there's sort of two things that could be the transaction at issue. Either the transaction that set up the structure, so the formation of the subsidiary and the contribution or transfer of all the intangibles to it, or the payment in the current year. Well, this is a bit of an academic debate maybe, but it seems like the reason that you're making the payment in the current year is because you have a legal agreement with a separate corporation. You have a legal agreement with a company. The transaction that set up that legal requirement that you make that payment occurred 5, 10, 20 years ago, whenever you set up the Intangible company. The business purpose, for that reason, the business purpose that one would need to evaluate would need to be the purpose of the transaction was set. The reason that you're making the payment in the current year is to further the business purpose that the structure was initially set up. It is so that a court, for example, respects the structure, does not pierce the corporate veil if an intangible holding company is sued. The reason for the current year payment is whatever purpose the initial structure was set up for. So what is the principal purpose? Well, again, it's helpful to look at draft legislation here. So the draft legislation said the exception applies unless a principal purpose was the avoidance, of Pennsylvania tax. And so under the draft legislation, if you had 5 purposes and one of the principal purposes was the avoidance of Pennsylvania tax, arguably the Addback exception would not apply because one of your purposes was avoiding Pennsylvania tax. But the legislature did not adopt the word a, they used the word the. So the Addback exception applies unless the principal purpose is avoiding Pennsylvania tax. And there's sort of 2 consequences that flow from that. The first is that your setting up the structure had to have a principal purpose. So it wasn't done for a number of equally weighted purposes. And the second, that principal purpose, that sole principal purpose, was the avoidance of Pennsylvania tax. And the department does not appear to disagree with that. The bulletin says that there can only be one principal purpose, and that is the single and most significant reason that the transaction was conducted. Something that's very interesting about Pennsylvania statute and what makes it an Addback like no other is that the MTC model Addback statute and the Addback in most other states required a non-tax business purpose for a principal purpose exception to apply. Or said another way, you had to have a reason other than the avoidance of tax for the exception to apply. Pennsylvania is a little different. You can be avoiding any other tax. You can avoid New Jersey tax, you can avoid federal tax, and that will qualify as a principal purpose. It will qualify as a purpose other than avoiding Pennsylvania tax, and you get the Addback exception. So we have yet to have that case. It would be a great one because it's just so clear. But maybe if you are going to present substantial evidence that the reason that you set up the structure was to avoid New Jersey tax, for example, there might be some downside. We're going to talk in a minute or 2 about Sham Transaction, and in a way, all the evidence that you put forward to support a principal purpose that is the avoidance of another tax might give the department more ammunition to attack the structure using a different theory. They could argue that the structure was entirely a sham. Setting the Addback statute aside entirely, they still get to disallow the deduction. So again, going back to sort of legislative history is helpful here. This isn't traditional legislative history that we would cite. It's not a debate between legislatures, but it is a document that was circulated amongst legislative members that says that this statute that you're about to pass, the principal purpose exception, is so broad that it's possible and very likely that all affected intangible expenses will be considered to be for valid business purposes. And therefore, this group of legislators concluded that the Addback provision will result in no revenue increase to the state.
Yeah, I think this is important. I mean, all these, it's just make way because these are really facts and circumstances cases, as everybody knows, that's involved with them. And you've got, good Delaware holding company cases, and you've got really bad ones. And I think that some of this legislative history and the comments being made will help in interpreting the statutory provision in a way that we think is really most beneficial to taxpayers because, the theme running through all the comments that were made during the passage of this legislation was, as I started this seminar on, we are eating up the Addback statute with the exceptions. And there's really no Addback. And when you read this note, the physical impact, they're saying we're never going to get this money with this legislation because these exceptions you can drive trucks through, and they're very broad, and they're always going to apply. Although we think we're adding a, as it says here, Bill 2150 falsely claims to close the Delaware loophole, and the conclusion is based on everything that at least the legislature, legislative people that are writing these bills is telling us is that it didn't work. It just didn't work. But that's not preventing the Department from issuing assessments. But what we're suggesting is that it may prevent them from actually having those assessments upheld.
Yeah, and you might ask, well, why are there a bunch of assessments if this exception does eat up the statute? And it really, I mean, this is the legal answer, but it really comes down to facts. And the department assumes that the principal purpose is the avoidance of Pennsylvania tax, unless you can prove otherwise. And the problem, going back to which transaction you need to evaluate to prove principal purpose, it is, the transaction set up the structure that probably happened 10, 20, sometimes even 30 years ago. Yeah. And it comes down to, do you have records from that time? Did records exist in that time where, the board, for example, the ideal thing would be board minutes. So the board considered setting up the structure, and they've got a list of reasons the board voted. And so it's very clear from documentary evidence that the structure was set up for a number of different reasons. Quite frankly, that is very hard to come by. We've never taken over an appeal, and that's existed. In lieu of that, another, and we'll talk about this a little bit later, but if you have people in the company that were around when the structure was set up, you can use affidavits and get them to say, well, the state of mind of the people that put this in place was X. It was, for example, our legal department decided that this was a good idea for liability reasons. And then, for them, the principal purpose to set up the structure was, had nothing to do with tax. And that's the sort of evidence that you would want, and really need to present to try to support this exception. To summarize where we leave this. So the exception applies unless the transaction has a principal purpose, and Pennsylvania tax avoidance is that purpose. Again, as we said a couple of times, it's incredibly broad.
Yeah, I mean, look, here's at the end of the day, what's going on here is there's going to be a debate about how the statute's supposed to be read. The department is saying that you have to have a principal purpose that is a valid business purpose. And we say that's not what the statute says. The statute says that as long as my principal purpose was not Pennsylvania corporate income tax avoidance, I'm good. I qualify for the exception. That's it. That's what it's going to come down to. And, I don't know where that's going to come out, but we'll see. And I think the last bullet point on there, Sebastian, is the scoring on this. I think that and again, there's some legislative history out there that shows what the scoring is. Scoring meaning that, what revenue they think they're going to bring in, using the MTC model, which was the original model, versus using what actually got passed. And the scoring on that says that between 70 and $90 million was the scoring for the MTC model. And then you say, okay, well, got passed. And the Department of Revenue and the legislature said, well, this is only going to get us between 10 and $30 million if we pass it this way. So again, we think that gives a lot of support for the credence that it's a very, very narrow Addback statute in Pennsylvania.
Narrow statute, broad exception.
Broad exception, yes, thank you. Exactly.
All right, so first polling question. So, as we've said, most of what we see centers around the principal purpose exception, but we'd be interested to hear if other people are applying or using these other exceptions. So the question is, what Addback exception is relevant to you? Principal purpose, conduit, excuse me, foreign treaty, no exception, you take the Addback credit, or you don't have an Addback issue at all, and you're just here for CLE credit. So again, you do need to answer these questions to get CLE or CBE credit, so please do that. We're not going to go through the answers. We'll leave the question up for 2 minutes, but just make sure that you answer it. Okay, so let's go back to the statute. So this is the last sort of interesting, sometimes perplexing language in the statute. The statute says that the Addback is in addition to any authority that the department had before Addback to deny deductions based on sham transaction. That raises a number of questions. The first is, what was the department's sham transaction authority before Addback? Well, first of all, just very briefly, what is sham? Well, it's a federal common law principle that developed in a number of cases going back almost 100 years, where the IRS disallows transactions that don't have economic substance or business purpose. In the federal context, it comes up mostly in the area of transactions, and far less in the context of disregarding separate entities, which is the way that Pennsylvania and other states that have asserted this historically at the state level have applied sham. So sort of for that reason, there's a lot more state authority on sham transaction as applied to disregarding separate entities than at the federal level. Where did this come from? How did the sham transaction, this federal doctrine, get incorporated into Pennsylvania law? Well, there's no statute that explicitly does it. There is a federal statute that codifies the economic substance doctrine. There is no Pennsylvania statute, and there is no. I would say there is no court decision. There is this case out there called Pitty, and the Board of Finance and Revenue has relied on this Pitty case to say that sham transaction applies in Pennsylvania. The problem is that Pitty didn't really involve sham transaction related to tax at all. It was a fraud. Two individuals were going to get their land taken as a result of a tax sale. It's the only reason the tax was implicated. It was a tax sale. But they recorded a mortgage on the property before the sale, and then sought to enforce that mortgage against the purchaser. It was really a fraud case. Really did not have anything to do with sham transaction. But the court does cite some of the historic federal common law sham transaction cases. The Board of Finance and Revenue, which is the second administrative appeal level for tax assessments and refunds in Pennsylvania, kind of looked at that and picked up on that discussion and said, okay, sham transaction does apply to Pennsylvania, the department can raise it.
Yeah, and they just put the same paragraph in every single decision from the board dealing with intangible holding companies that never really addressed where is the line between a sham and not a sham, which is not a lot of help, there. But I think one of the questions, Sebastian, here is that I think Pennsylvania, remember, is a separate company state, as everybody knows, and what the statute says is Pennsylvania taxable income shall be federal taxable income as would have been returned to and ascertained by the federal government. As would have been returned to and ascertained by the federal government. So to me, there's some question about that language in the statute and whether that, as would have been returned to the ascertained by the federal government, brings in all of the federal law, the sham transaction doctrine that Sebastian's talking about. And so that's kind of an open question out there remains, whether how much authority they have and what they haven't had. And look, the reason we're talking about this now is because, I'll talk about the history in a minute, but the sham transaction is still sort of behind the scenes really in the Addback statute. We have this Addback statute, but when you get into the principal purpose, it's kind of hard to separate the principal purpose is not tax avoidance without talking at least around or about, well, this is a real transaction, which means it's not a sham transaction. And so that's why it's still kind of applicable and still question about how much authority the department has to apply this provision, the sham transaction doctrine at all, to these transactions, but an open question.
Yeah, so pre-2015, before Addback, the department was asserting sham to disallow the exact same deductions and the exact same factual scenarios that it now applies the Addback statute to deny. There's still a whole number, half the cases at court now still involve pre-Addback year sham transaction. But the real question is for years 2015 and after, can the department apply sham even if you meet the principal purpose or some other Addback exception? I mean, there's definitely an argument that they can't. There's some principles in the Pennsylvania Statutory Construction Act that would suggest that because the legislature has enacted an Addback, that Addback is intended to encompass all of the department's authority as it relates to adding back intangibles. You would say that the department included the language in the statute to cover things that are not covered by any of the exceptions. That's an argument that could be made. It might be a little bit tough just because this goes back to a point we were talking about earlier. If you put out a whole lot of evidence to avoid New Jersey tax, the only reason I set this thing up was to avoid New Jersey tax. I didn't have any board meetings. I didn't have any transactions in place, any agreements. But I met the principal purpose exception because I was avoiding New Jersey tax,
as opposed to Pennsylvania.
Yeah.
Does that make it a sham? That's the question that we've got. I don't know the answer to that. Nobody does, but
yeah. Judges are people too.
Right.
We like to think in sort of hyper-technical terms sometimes, but even when the statute is completely clear, the courts will sometimes ignore that clear language when it doesn't feel right. In this case, there is language for the court to point to in the statute that they could kind of hang their hat on to apply sham, even if you need an Addback exception.
All right, so moving to now, let's start to talk about kind of where we are. Oh, sorry.
Just one polling question.
Yeah, go ahead.
Is this one more polling
question? Requirements here. Sorry.
So do you have a pending Addback or sham issue? Here, we're sort of interested where taxpayers are, as a whole. Once a Board of Finance and Revenue decision is issued, or once the case is appealed to court, it becomes public, and we track those. But interested to know: do you have pending Addback or sham issues at audit, at administrative appeal, which would be the Board of Appeals, Board of Finance and Revenue, or at court? Or no, you don't, but you've got the structure. It's sort of always been on your radar that the department could assert it. One thing maybe I'll just mention there substantively is, even we've seen situations where the department has looked at a transaction in pre-Addback years and not assessed it based on sham, but has now, because of the Addback statute, maybe they feel a little bit emboldened and has decided to assess it now. So I would say that even if the department's looked at your structure and you think it's not an issue, if they looked at it in a pre-2015 year, that does not mean that they will not re-examine it under the new Addback universe that we're in. Or E, again, you're just here for CLE and CP credit and listen to us talk. So again, we're not going to go over the answers. The question will be up there for 2 minutes. Please just answer it when you have a second.
Okay, so now let's move to the phase of the presentation where we want to talk a little bit about kind of where we are. When I say we, where are the cases, where are the assessments, where are the appeals, what's going on? Before we get to that phase of it, just for the folks that may not be familiar with how the Pennsylvania appeal process works, when I throw around the BF&R terms and court and Board of Appeals and audits, just want to make sure that, this is on your screen there now, and this slide goes through the 5 phases of tax appeals really in Pennsylvania. First, you've got your audit. Then you go to the first appeal goes to the Board of Appeals, which is part of the Department of Revenue. You get an informal hearing. Then you go to the Board of Finance and Revenue, which is an independent 3-member board now. And at that board, there's an ability to have discussions with the counsel for the Department of Revenue. There's still a briefer that's at the Board of Finance and Revenue who will brief the case, but the board has, there's lawyers for the Department of Revenue who represent the Commonwealth at the board. And so there was discussions with that lawyer about the case to see whether you can resolve the case through a negotiated settlement, or you're going to have to go to an argument at the board. The argument at the Board of Finance and Revenue is 5 to 10 minutes. Decision gets issued, a month after that, or a couple weeks after that, and then a month after that, at 30 days, you've got to appeal to Commonwealth Court. Commonwealth Court in Pennsylvania is an appeal de novo, which means that there's no record established at any level of the board. But having said that, I would make it clear that all the issues have to be raised at the administrative level and preserved for appeal. So any issue you want to raise in Commonwealth Court has to be preserved, properly raised and preserved at the administrative boards to be discussed in Commonwealth Court. And I will mention that in my 32 years now doing this, the Department of Revenue and the Attorney General's office have been extremely aggressive on whether you have in fact raised the issue. And there's some case law out there dealing with what that means exactly, raising the issue properly. But it's a very aggressive area right now for the department. They are trying to throw out as many cases they can on jurisdictional grounds. So cases get filed in court. The first thing they're starting to look at is, well, all the issues that you're talking about here, have they been properly raised and preserved for appeal? So I think the taxpayers need to be very careful in this area and make sure that you preserve all the issues at the administrative appeal boards.
Can I shove it out more? The other thing is that, 9 times out of 10, if we're just taking over an appeal at court, there are other issues there. Oftentimes the taxpayer will come and say, okay, I've got this one issue, it's Addback. Oftentimes there are other issues or other positions that we can take. And the more issues you have, the more that you raise if you're interested in settling the case, the more settlement value that your case has. So it's important to raise as many issues as possible and draft your appeal petitions incredibly broadly so that you are preserving all issues, just in case something comes up that you didn't anticipate, you didn't see at the administrative level, but that might be an issue when you get to court.
Right. And so you see on the screen there, 95% of the cases of Pennsylvania do get settled through negotiated settlement. And then the Pennsylvania Supreme Court is the next, is direct appeal. One of the few tax cases go directly to the Pennsylvania Supreme Court. It's appeal right. So that's the procedure. Let's move on to the next slide there, Sebastian. So let's talk a little bit about the history and the Delaware Holding Company issue. I'm envisioning this as kind of 3 rounds. And I'll start from the beginning. I think you need to understand sort of where we began to get a full flavor of sort of where we are now and perhaps where we are in round 3 that we'll talk about here at the end, which is the nexus issue. So the history of this, back in 1989 when I started doing state and local tax, I'll never forget sitting at a meeting with the Pennsylvania Economic Development Authority people talking about trying to get incentives to come to Pennsylvania. And the comment from the official there was, and I'm a first year, second year associate, and I was like, what does that mean? And what he said was, well, you should talk to your tax advisor. Meanwhile, I'm the tax advisor, but as a first-year associate, I didn't know I was a tax advisor, is that, Pennsylvania, has a high rate, back then it was 10.5, whatever it was, high rate of corporate income tax, but we're a separate company state. So make sure you talk to your tax advisor about what exactly that meant. And so back then, everybody was doing it. Everybody had holding companies, as everybody on the seminar here knows, and it was kind of routine. Everybody had holding companies, payments were made, deductions were made, blah, blah, blah. So then fast forward to like 2001, somewhere around there, this is round 1 of the Sham Transaction. So the department decided and the auditors decided that they were going to go out and look at not all, as many as they could. It really started out in Pittsburgh, Western Pennsylvania, trickled across the state, and had some fairly aggressive auditors who decided this was going to be their thing. They were going to go look at all of the intangible holding companies, and they issued lots of assessments. As you can see on the screen there, this is in the period 01 to 11, there are about 100 cases that got filed in court. And at that point in time, the Attorney General's office and the Department of Revenue said, we're going to find some of these cases to litigate. We think that we're really looking for the truly sham transactions. We're looking for the taxpayers who didn't know where Delaware was, didn't have real agreements, didn't do anything related to having a real intangible holding company. And we're going to look at all those, and we're going to find one of the cases that is bad, and we're going to litigate that so we can establish really was their view that there is a sham transaction doctrine, and here's how bad these taxpayers have been. So we were all the tax bar was moving forward with all these cases, and at the end of the day, all those cases got settled. None of them got litigated, and the settlements varied really depending on your facts, from 10% relief to 80% relief to 80 or 90% relief, and go forward, we won't bother you anymore. So that was round 1. Fast forward now, that's 2001, 2011 Sebastian. Now fast forward now to round 2. Round 2 is where we are now, right? Which is we've got the Addback statute. Don't forget that it was enacted in 2013, effective for 2015 tax year. And so when it was enacted, that's when you get the activity that starts to come in, which the activity we're talking about right now, the audits and the assessments. So they started about 16 or 17. And there are cases that are a mix, as we say. There are about 39 cases right now that are pending in court. There's a mix of pre-Addback statute, pre-15, and post-Addback statute, post-15, for the same taxpayer. And what's interesting about that point is that, the department, despite having the Addback statute in place, their audit position, interestingly, has just been all the same. If you've got an Addback, issue the assessment, arguing that there's no business purpose, and not really making any distinctions between, Addback years 15 and forward and old Addback years. So we've got a bunch of those. Now, you can see on the screen there we have about 15 cases that were in court that got settled, and various facts that took place. And we actually had some cases that got settled at the Board of Finance and Revenue as well. So there's an opportunity to settle some of these cases, the Board of Finance and Revenue. And one little footnote there, of course, the department is going to try to lowball you and give you a low settlement at the Board of Finance and Revenue under the theory that you may not be filing a case in court. So they'll, if you're willing to take, 50% at the Board of Finance and Revenue, that's okay. We'll take that. Although they know that, ultimately, if you go to court, you may get more. Time value, money, expense, and all those things. They're kind of keeping those settlement offers at a pretty low level. So that's kind of where we are right now. The Board of Appeals, I just mentioned, nothing. The Board of Appeals is not granting any relief on these. They're just going to the Board of Finance and Revenue. And go to the next slide, Sebastian. So, so you go to the Board of Appeals, you get nothing. Then you go to the Board of Finance and Revenue. The Board of Finance and Revenue, to jump down to the bottom here, there's been one decision in favor of the taxpayer. And that decision was, not a Delaware holding company. There were royalty payments between an affiliate and the taxpayer, but it was a company that wasn't headquartered in Delaware. It was a company that had IP attorneys. It had all sorts of real substance to it. And the Board of Finance and Revenue looked at that case and said, yeah, that's one that we're going to pass on, and we're going to say you're entitled to not have the Addback of the royalty payments. I mentioned before the settlements are possible, so always keep that open when you're at the Board of Finance and Revenue. We've got a couple cases that we have settled, and we've got a couple interesting cases that are in the pipeline right now that you want to keep an eye on. That are pending at the Board of Finance and Revenue or going to be pending at the Board of Finance and Revenue. And, these cases, as I mentioned before, are all sort of facts and circumstances focused. And the cases that we have coming through are, I would describe as we have some that are really good and some that are like the case that the board granted relief on, meaning that they've got royalty payments coming from an affiliate that has manufacturing in it, that has real substance, lots of people, lots of employees all over the place. So those are going to be interesting to see if we can get the same decision. Then we have a number of cases that are, what I would describe as real Delaware holding company, but everything was done appropriately. And they've got some real good documentation on why it was done. Board minutes, agreements between the entities, everything that you'd want, that we want in litigating a case. And so we're anxious to see if we can convince the Board of Finance and Revenue on that sort of middle of the road. Everybody knows this is a Delaware holding company case. Can we get relief from the board? And this is going to come back to that question that I posed earlier, which is, is it enough really for us just to establish that the principal purpose was not to avoid Pennsylvania tax? We have all these other purposes, and one of them is a principal purpose. But if we can show that our principal purpose in setting up these holding companies was not to avoid Pennsylvania tax, can we win? So stay tuned. More to come on that. We'll see how that goes.
The BFR has denied the vast majority of these cases. And it seems like perhaps one of the biggest problems in these cases is that there are sort of generic assertions of business purpose, centralizing IP without any contemporaneous evidence from when the structure was set up. You can argue until you're blue in the face about the purposes, but if there's no document or nobody that was around at the time that it was set up to attest to or to sign an affidavit, there's got to be something in the record that shows what the business purpose was when the structure was set up. And that seems to be the thing that's lacking in the vast majority of these cases that the BFR has denied.
That's right. That's right. So go to the next slide, Sebastian. I mean, so we get this question all the time. So what do we do, right? The question is, what do we do? How do we defend these structures? What's the best? And I think and when do we start, right? We've got an auditor, they're auditing, it looks like they're looking at the structure. What do I do? What do I do? The most important thing from our perspective is that develop the narrative early, okay? Develop the narrative early, develop the facts, understand what your narrative is. And that has to be done on day one, talking to the auditor, year 2, talking to the Board of Appeals, year 3, talking to the Board of Finance and Revenue, ultimately going to Commonwealth Court if necessary. But it's critical that you develop that narrative and maintain that narrative from day one, okay? And you have as many documents as you can to support that narrative. There's a lot of narratives that can be developed here. We've got things all over the board. Sebastian touched on them a couple times ago, and why these things are structured, and talking to the company people. But well, I know tax had a benefit, but we set up this separate company because we were in the midst of litigation, and we had a product that was on the verge of having this huge class action set of cases against it, right? And so we wanted to protect our marks from any sort of big class action litigation or bankruptcy or anything that was going to happen, and talk to the people. And you got to start the narrative early, because I cannot tell you the number of times that I get to the Board of Finance and Revenue or Commonwealth Court and sit down with the Attorney General and sit down with the lawyer for the Department of Revenue. And we have developed a narrative over the past year, but that differs a little bit from the narrative that was developed 3 years ago at audit. And so when that happens, then it throws suspicion into sort of what the actual narrative is. So you got to have the substance, and you got to have the narrative from the very beginning, and as much contemporaneous documentation as you can. And one of the things that we've been doing now is to try to get some affidavits. If you don't have a lot of documentation, get some affidavits from, at best, of course, of people that were around back then when these holding companies were set up. That's the best. Get as much documentation as you can.
I just wanted to expand on one thing you said there. Did the company set up the structure at a time when there was some sort of litigation pending? If the structure was set up so long ago that you don't have documentation, don't have people around and directly involved that you get an affidavit from, there's oftentimes a story around when the structure was set up, and that can be persuasive, and it can go a long way.
Yeah, and just 2 other points here on the Addback. Don't forget, you get the exception to the Addback unless the principal purpose was avoiding Pennsylvania tax. So one of the couple things to look at, again, we've mentioned it once already, is, well, no, because I saved more tax in New York. And don't forget, it's at the time of the setup. So go back. Okay, when I set this up, did I save more tax in New York? I know they're combined now, but back then, did I save more tax? Okay, then you got a good argument that the exception should apply, because look, I saved more tax in New York, so in Pennsylvania, so the principal purpose could not have been eliminating my Pennsylvania tax liability. And also make sure you look at the tax liability back then when you set it up. Sometimes these things get set up in a year where, when I used to be doing this and setting these up a long time ago, we would love to set them up in the year when the company had losses. And you set it up that year, and then 2 years from now, there are no losses. And of course, that when the savings kicked in. But don't forget, statute says at the time of the setup, at the time of the quote unquote transaction. And the transaction is setting up these companies. So keep that in mind when you're thinking through about how best to defend the structure. Yeah, so I'll tee this up real quick. So the last piece of this, and this is round 3 of the Delaware holding companies, and round 3 again, as I mentioned early on, is nexus for the Delaware holding company. Can Pennsylvania take the view that, okay, we're not going to deny the deduction by the Pennsylvania taxpayer, but this company down in Delaware, it's got nexus with Pennsylvania. And that has not happened yet. We've had some discussions with the chief counsel at Department of Revenue about doing that and whether they're going to do that or not. And you get some of these fuzzy answers on that question and fuzziness. Well, we can. So Sebastian, why don't you walk us through sort of what's public that's out there? But that's kind of the big picture view on where we are on this nexus thing.
Yeah, so to give you a little bit of comfort, the department has said that they will not go back and assert economic informally, so they could always change their mind, but it has informally indicated they're not going to go back and assert economic nexus over intangible holding companies for periods before 2020. Why 2020? The department released, and we do a whole webinar on this, but the department released a bulletin, 2019-04, where they take the position that Wayfair, they say Wayfair confirms that for corporate net income tax purposes, physical presence is not required. Now, because they use the word confirms, you might think that their position has historically always been that physical presence is not required, so they could go back and assert physical presence in pre-2020 years. But again, informally, they've said they won't do that. They're only going to assert economic nexus, if they do it at all, over intangible holding companies for the effective date of the bulletin, their economic nexus bulletin, which is effective for tax year, for calendar year taxpayers. It's effective for tax year 2020. That means that this return's due this fall. So one question that that's come up almost for all of our taxpayers that have these add-back issues is what they do in 2021. Do they file a return for their intangible holding company, try and start closing the statute if the department asserts nexus over it? There's a lot of considerations that go into that. So more than we're going to cover here, but I do want to sort of mention two questions that are sort of you should consider. One is whether the department is right that that Pennsylvania nexus for corporate net income tax is coextensive or equal to constitutional nexus. That is, does the Pennsylvania statute require some sort of physical presence?
Yeah, on that topic, because we don't have time to cover it today, we wrote an article in State Tax Notes, did November 18th of 2019. It goes through all that analysis, and at the end of the day, the punchline is that we think that the nexus provision for income tax in Pennsylvania requires fiscal presence. Read that article if you're interested in that issue, and that issue comes up because it gives all the detail and background behind it. Again, that's November 18th of 2019, State Tax Notes.
We'll include it with the materials as well. So yeah, just the one thing I'll say that makes this argument, in addition to sort of the statutory language that we have, there's some taxes in Pennsylvania statute that are explicitly imposed to the extent of the U.S. Constitution. The corporate net income tax is not.
And other taxes in Pennsylvania are, which makes it interesting. Right.
Like the bank shares tax, for example, and a couple others. So the second question is, okay, even if your intangible holding company has economic nexus, the question is, does it have Pennsylvania source receipts? Just that question alone we can spend an hour on. So I was going to say the long and short of it is there is litigation going on where the department is taking the position that cost of performance, which is how interest and royalties are sourced, is sort of sourced on a market-based approach rather than the company's headquarters, rather than where one traditionally thinks of its costs as occurring. There's litigation ongoing involving that question in the services context. The department has been successful in asserting that position in the Commonwealth Court. That case is now in the Pennsylvania Supreme Court. The question is, A, are they going to win that case? And B, if they do, are they going to apply that cost performance outcome to interest and royalties? Yeah, and this is a perfect point, Sebastian, to highlight the issue that we were talking about earlier, which is preserving issues for appeal. I can picture taxpayers getting assessed on their Delaware holding company and saying, no, I don't have nexus, and to bring the case all the way to Commonwealth Court and never raising the question, well, even if I do have nexus, my apportionment is zero because of the Pennsylvania sourcing. And so that's a perfect highlight of be careful as you go through the administrative boards and don't assume that your case is only about nexus. Okay, maybe I do have nexus. I don't think you do, but maybe I do. But even if I do, what is the apportionment factor that gets applied? And if you don't preserve that, you're not going to be able to raise it in court. So be careful on that point. Yeah, one thing I'll also say is, didn't the department have practice for a while? If you filed a return with zero apportionment, in some situations, they just issue an immediate assessment for 100. Yes. So sometimes filing a return for your intangible holding company is going to be, an invitation to an automatic assessment. Yeah, on that question, we have not been in favor of filing returns because I think it's going to highlight the question. Well, returns by the holding company, because I think it's going to it will raise the issue sooner than you need to. And again, going back to what point that we made at the very beginning, the department's Wayfair economic nexus bulletin is just a bulletin. It is a statement of its litigation position. not a regulation or statute. Last polling question, just interested to know if you're considering filing a Pennsylvania return for your holding company. So put it all together. So Addback, again, we've said this multiple times, sort of the takeaways. The principal purpose exception legally sort of consumes the Addback. The exception is so broad that the Addback is very narrow. But to get that as a factual matter, you need to develop your facts early, and you need to establish the principal purpose with documentary evidence. Make sure you're appealing any assessment, even if it's small and you know you're not going to litigate it. Know that cases are settling. You might be able to get relief, some sort of relief. Follow the litigation that's out there. There's no cases based on what we're tracking that are sort of poised and set to go to litigation in the Addback or Sham space, but that can change very quickly.
And one thing I'll add here, Sebastian, I think is that there may be some taxpayers out there that actually did the Addback and didn't follow the exceptions, because to me, in the number 30 cases or whatever, there probably are not enough assessments to match what I think is going on in the tax world. So if you're one of those companies that didn't have time to study the Addback provision, realize that it was consumed by the exceptions, and now after the seminar, perhaps you realize that maybe you could apply for one of the exceptions. Refund claims is 3 years from date the returns due. So you might want to think about that as well.
By the way, what the date the return is due is original due date in Pennsylvania. It's just an exception, like most states. So just be aware that for calendar year taxpayers, the refund deadlines are due in generally May. So as far as the nexus, the takeaways: watch out for assessments. As Lee put it, round 3 of this whole intangible holding company, the department's approach to tackling them, and really the important point with nexus is, regardless of the department's nexus position, the key sort of is sales factor. Sales factor sourcing your intangible holding company very likely does not have Pennsylvania source receipts because they're based on cost of performance. So thank you very much.
Yeah, thanks everybody for coming. Really, we really appreciate joining us here today, and thanks for answering the polling questions. And if you have any questions, our contact information here is on the last slide. Happy to talk with anybody about anything that they may want to discuss related to this topic. Just give us a call, and we appreciate your time, and enjoy the rest of your day.
Take care.
Thank you.